Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, here at Washington Gun Law, we get to cover a lot of stupidity quite often. Yeah, we get to talk about stupid rulings, stupid laws, stupid legislators, stupid judges, and occasionally we get to talk about stupid lawsuits. And this is one of those days. But this is a lawsuit that really has much deeper meaning than that, because this is a lawsuit that's really about a city that continues to double down on its failed policies, and despite the fact that it has an ever-increasing violence problem, is not looking to change its policies, but rather looking to scapegoat this onto another company. That's exactly what's occurring here. We'll connect the dots. And so today, let's spend a few minutes and let's talk about Chicago sues Glock in the most absurd lawsuit you'll ever read. You watch the news, you read the headlines, and you know it for yourself. Your community is less safe than it was just a few years ago. So you decided to purchase your first firearm. But like everything else in your life, you wanted to do this lawfully and responsibly. So you trained and trained and trained. You learned the laws of self-defense and all the tactics necessary to protect yourself and your family. To this day, you continue to train, and you now live by the motto that it's better to have it and not need it than need it and not have it. You are prepared for anything. Or so you thought. Who are you going to call when it all hits the fan? Who's going to defend you for defending them? Who's going to stand in your corner when you realize that proof beyond a reasonable doubt means one thing in a high school civics class and something altogether different in the real world? Introducing Right to Bear, self-defense coverage that protects you so that you can protect them. With an attorney-answered hotline, you will always get a confidential conversation with your state's attorney. There are no cap limits for either criminal or civil defense. All forms of self-defense are covered, so from a fist to a firearm, you are protected. And you will have some of the nation's most passionate 2A attorneys defending you. And the peace of mind that you will have knowing that Right to Bear is in your corner, well, that's priceless. Listen, I've been in this industry long enough to know two things with absolute certainty. Good lawyers aren't cheap, and cheap lawyers aren't good. So visit my friends today at protectwithbear.com, and if you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, this is what we're talking about today. We're talking about the newly filed lawsuit of City of Chicago versus Glock Incorporated. This is a lawsuit obviously brought by the City of Chicago against the Glock handgun manufacturer for what? Glock switches. And you go, wait a second, does Glock actually make Glock switches? No, of course they don't. But hey, why let that get in the way? Now, for some of you who may not know what a Glock switch is, according to the pleadings, and again, I'm not vouching for anything that the City of Chicago says here, but according to the pleadings, this is what a Glock switch does. Glock-style auto sears, which look very much like small Lego pieces, can be attached to the back of pistols. The auto sear has a small protrusion called a disconnector that, once installed, pushes the pistol's internal trigger bar down, allowing the striker to continue firing as the slide reciprocates with recoil. The ability to fire continuously without the shooter having to pull and release the trigger repeatedly allows for a much faster rate of fire. Now, whether that's what occurs in the internal workings, I will not vouch for. I will say that the videos I have seen with firearms installed with these, yes, the rate of fire is much faster than what you would see out of even a very skilled shooter. Now, of course, the other problem is that there's been a huge proliferation of these turning up in crime scenes. I do believe the data bears that out very well. And of course, the problem is that Glock is making these things. Oh, that's right. Glock doesn't make these things. No, these things are often made in China by some cheap manufacturer, illegally shipped to the United States. Now, the problem that Chicago has, though, is the ease of installation to the Glock handguns. So, what exactly is Chicago complaining about here? Well, it's a 44-page complaint, all right, and request for declaratory relief. But they don't even get to the actual pleadings, that is, what are they pleading the law under, until they're on page 29. So they spend the first 29 pages basically just painting this horrific story, telling all these horrific tales. It's all hyperbole and conjecture, but you need to understand, because let's remember, this suit is being filed in Cooks County, Illinois. Glocks affixed with auto sears can fire fully automatically up to 1,200 rounds per minute, a rate as fast or faster than many fully automatic firearms used by the U.S. military. Over the past 2 years, from the beginning of 2021 through December 31st, 2023, over 1,100 modified Glocks have been recovered by the Chicago Police Department. These terrifying weapons have caused death and destruction throughout Chicago. They have been recovered in connection with homicides, aggravated assaults, batteries, kidnappings, burglaries, home invasions, carjackings, and attempted robberies. Or, as we like to call it, just another day in Chicago. The problem apparently is the Glock switches. It's not all the people that they're not holding accountable for, right? The plaintiff continues to state Glock pistols are the most popular firearm in America. They are also the firearm most favored by criminals, particularly in Chicago. According to the ATF, over 8,000 Glock pistols were recovered in connection with criminal investigations in Chicago from 2017 to 2021. Thousands more than the next most popular crime gun. Glock's popularity within the criminal market is owed in part to the ease with which Glock pistols can be converted into machine guns. Now consider this. If the argument was, hey, the Toyota Camry or the Honda Accord or the Ford F-150 is the most commonly used vehicle in DUI accidents, therefore we need to go after Ford or Honda or Toyota. That's akin to what's going on here, okay? Now, the city of Chicago continues this way. Due to the susceptibility of Glock pistols to modification and Glock's refusal to correct the problem, anyone with $20 to $25 to spare and a desire to circumvent long-standing federal and state prohibitions on possessing fully automatic machine guns can do so by buying an auto sear and affixing it to a Glock pistol. The task can be accomplished with a common household tool like a screwdriver, and it typically takes less than 5 minutes with instructions readily available online. But again, these are devices which are not being made by Glock, are not legal in nature, and being illegally attached to otherwise legal Glock firearms. What's the problem for Glock? Well, this is how Chicago connects it. Glock has known about this dangerous workaround for years. So prevalent is the practice of installing auto sears on Glock pistols that they are commonly known as Glock switches, because they allow shooters to toggle between semi-automatic and fully automatic firing modes. Many auto sears are even sold with the Glock logo printed on them, even though Glock does not manufacture them. Glock's willful decision to not take any meaningful action to address this problem in its sales to civilians, despite its awareness, is immoral, unethical, oppressive, unscrupulous, and unreasonable. Wow, can you believe that? Glock's unwillingness to address an illegal action, which is banned by both state and federal law, that Glock does not endorse in any way, shape, or form, is, as they put it, immoral, unethical, oppressive, unscrupulous, and unreasonable. Where ultimately the city of Chicago is going to come down on this is under some Consumer Protection Act violations. And so they start setting up the argument this way. By choosing to continue selling and marketing its easily modified pistols to Illinois civilians, including to Chicago non-law enforcement consumers, and refusing to implement simple changes to its pistol design, Glock has violated numerous obligations under municipal and state law, including by failing to institute reasonable controls and safeguards to prevent the unlawful possession of its pistols, knowingly creating, maintaining, or contributing to a condition in Illinois that endangers the safety or health of the public by conduct either unlawful in itself or unreasonable under all circumstances, and engaging in unfair acts. Okay, so the city of Chicago is basically blaming Glock for the illegal activity of multiple other players, of which Glock has nothing to do with it, okay? That is the absurdity of this lawsuit. But wait, there is more. You see, apparently the city of Chicago has a real beef with Glock on their Gen 1 through Gen 4 versions of firearms, but apparently not quite as big a beef with their Gen 5. The pleading state for Glock's Generation 1 through 4 pistols, which have been produced for decades since Glock's entry into the U.S. market. Installing an autosear involves using a screwdriver to merely slide out the rear removable plastic backplate of the gun's slide and placing the autosear into the backplate's position. There are many videos online explaining how to easily accomplish this. Glock continues to sell Gen 3 and Gen 4 pistols to civilian consumers in the United States, including civilian consumers in Chicago. Glock's Generation 5 line of pistols, which entered the market in 2017, requires minor filing or clipping of a small plastic notch before an auto sear may be affixed. But they also argue it really poses no real true obstacle to it. So actually the Gen 5 really is just as terrible, evil, unscrupulous, and all those other things as the Gen 1 through Gen 4. Okay, so now I know you're asking yourself, what grounds are they actually suing Glock Inc. under? Well, we finally get there. We got to get almost 30 pages into the memorandum before we get there. But then we learn that there are actually 5 claims of action here, and they are as follows. First claim for relief, a violation of Municipal Code of Chicago 2.25.090, unreasonable sale and marketing of firearms. This law makes it unlawful for a business to engage in any act of consumer fraud, unfair method of competition, or unfair or deceptive act or practice while conducting any trade or business in the city, including any conduct constituting unlawful act or practice under Illinois Consumer Fraud and Deceptive Business Practices Act. So what Chicago is saying here is that Glock, selling a perfectly legal item, both under federal and state law, in compliance with all laws, all regulations, is still engaged in an unfair act because somebody, as an end user, oftentimes as the unlawful end user, decides to do more unlawful activities with what was once a lawful item. Second claim for relief, violation of Municipal Code of Chicago 225.090, unfair practice. This law makes it unlawful for a business to engage in any act of consumer fraud, unfair method of competition, or unfair or deceptive acts or practices while conducting any trade or business in the city, including any conduct constituting an unlawful practice under the ICFA. Just as ridiculous as the first claim, but wait, there's more. Third claim for relief, Municipal Cost Recovery Ordinance. Section 1-20-020 of the Municipal Code of Chicago provides that any person who causes the city or its agents to incur cost in order to provide services reasonably related to such person's violation of any federal, state, or local law, or such person's failure to correct conditions which violate any federal, state, or local law, when such person was under a legal duty to do so, shall be liable to the city for those costs. This liability shall be collectible in the same manner as any other personal liability. That's right, Glock, you are responsible for all of Chicago's gun violence. It's not the individual maniacs pulling the trigger. It's not the broken criminal justice system. It's not the defunding of the police. No. It's you, Glock, because you are making good handguns. Fourth claim of relief, public nuisance. I'm not even going to address that one. It's just as absurd as the other 3. And then finally, the last claim, fifth claim for relief, negligence. And then the other relief requested an injunction against Glock from selling their firearms inside the city of Chicago until manufacturing changes are made, design changes are made, so that the sears cannot be attached to it. Basically, what Chicago is not willing to do or is not capable of doing in policing its community, they just want Glock to do it for them. It is, in fact, one of the most absurd lawsuits you will ever read. The case, once again, is City of Chicago v. Glock. We'll link up it down below so that you can laugh on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.